All right, so for this afternoon's session, just for an hour, we're going to just do sort of a little bit of a reflective activity. You've been talked at a lot, and there's been a lot of sort of projects bombarded at you. So this is an opportunity now to really just have a look at some of those projects, and also look at other projects from your point of view in terms of what you want to do and what you're doing at your institutions and what your institutions are doing. So we'll probably just have a look at some different projects. You'll just have a search around from yourselves or within your discipline groups if you want to. I mean, I know there's a lot of librarians as well here, so that's obviously one distinct group we've got here. But just thinking about some of the things we've got on the screen there, I mean, there could be an element of sourcing potential resources if that's part of what you're thinking of doing. Issues, barriers, motivations, positive outcomes, negative outcomes. And also maybe just some projects that you'll find interesting, or there may be some on the list that we haven't shown and you know about or come across that you'd like to share with us. I've put, if you follow the link that's on the screen there, I've put a version of this PowerPoint as a Google Doc there. And if we can just go to that. You'll have a list of a series of websites there that I've just quickly put together around, you'll see the top two SCORE websites. The first one is basically a list of different case studies and projects that are going on around mainly Europe. The second one down is our fellowship programme, so our fellows all from English universities, looking at their research projects there. So quite a number of those have finished, so you'll be able to find case studies and publications on those there. And then we have UNESCO, OER Africa, some of the things that Andy mentioned. Links to the 3 phases of the JISC OER programme, as well as the HEA and OER Commons. And on the next page, I've just put together a list of everything that Andy mentioned. So that's all the projects that Andy mentioned there. I mean, some of them will be in all the other lists that you'll see around there, but if there was something in particular that interested you that Andy was talking about, you should be able to find it in that list. So what was the content that you were looking for that you couldn't find anything on?
Care worker role.
From care worker role. So, okay, so that's interesting, because that's probably quite likely that from that point of view, I would imagine there's quite vulnerable people involved in that. So I imagine people are probably maybe scared about the licensing and opening content up in that sense. Is there stuff on the internet that is available that is not open access around care work?
There's the Common Induction Standard, so if you wanted to take up a care worker's role, then there is stuff around that, but that's obviously from somebody's published material. Yeah,
I think that's quite interesting, because that's, from obviously the idea of the thought of it, and then how do you increase that? Well, it's been identified really that the arts were not very well funded in terms of the OER area, but I think that some of the projects that we've been involved in, particularly some of our fellows, has actually started to change that, and people want to look at them and find that. So it actually sometimes just needs those people to say, let's start putting some stuff in, and what are the issues around that, and how do we address it, and how can we actually make sure there is content out there. Interesting.
Okay, welcome back everyone. It's been really very easy going up till now, but now we get to the serious part of today. It has, come on, admit it, it's been a doddle, hasn't it? But anyway, we now get to the nitty-gritty of rights, everything to do with rights, and no one knows more about that than Bernie Atwell, who you're going to hear from shortly. But we have added value in the form of Alma Hayes, who's Director of Intellectual Property, is that right? Here in the university. So she heads the unit that looks after rights management across the university, across all courses, everything. So without more ado, over to you, Bernie and Alma.
Hi, good afternoon. My name is Bernie Atwell. I hope you enjoy this afternoon's session. I will say the time, I'll just go very quick, because copyright is such an interesting subject. And I know we're going to talk about Creative Commons, and I've got a few exercises to get you thinking about Creative Commons and how you might want to use Creative Commons within your work. However, we've got to frame that within copyright, because Creative Commons is not a religious movement or anything like that. It's basically a license, and people get so het up about it. And I think it's useful for you to learn a wee bit about copyright. Now, I do assume no knowledge, and that's why I've got the low-tech board here to sort of engage you. Today, you'll find this session a wee bit rushed, but please ask as many questions as you want. Alma and I do a course within the OU and outside the OU, and it lasts all day, to do with copyright and rights, the whole spectrum. So we've got a very short time to sort of just try and engage you, keep you awake, and get onto the interesting bits. So while I'm doing that, also can I bring to your attention you probably have it on your program, about the reflection tool. And if there's anything else you need as we go along in order to make this really work for you, then please fire questions. As Jonathan said, you've got 2 of us this afternoon, and make the most of it, because Alma, Head of Intellectual Property, also has a wealth of experience in dealing with rights and copyright for the whole university and with OERs. Okay. Here now, we're going to create a birthday card. A birthday card, even for those people that do not celebrate birthdays or anything, is just for the purposes of introducing copyright. And I need you all, with your most creative minds, to imagine this is our birthday card. And we'll have 2, an inside and outside. And this is the front of our birthday card. And then we'll go inside. But here, can you just give me some ideas as to what you would like on our birthday card at the front of it?
Balloons.
Balloons. Okay, balloons. You can see the artwork isn't that great. Okay, that's the balloons. Sometimes I have to indicate that it is balloons.
A footballer.
A footballer. Do you mean a photograph, an image, photograph of a footballer? Very well known
I think an illustration of one who looks like.
Looks like.
this one.
When you say an illustration, do you mean a cartoon type character, or?
Yeah.
Yeah?
Yeah, probably, yeah.
But have characteristics of somebody well known. Like if it was Gaza,
yeah.
you'd have them crying. Or somebody more up to.
Who do you look like?
Well,
Was that film?
to be honest, they're all going to look.
Egypt that he is.
Okay, we've got footballer. Let me. But it's an illustration. Okay. We'll put emphasis on Rooney's hair. Shall we? There's his wee shorts. And there's a ball.
So for the purposes of the card,
Yeah.
are we saying that that's been drawn by you, or are we saying that you've taken that from Flickr?
We could have taken it from Flickr.
I think, how about it's tracing of a photo from Flickr?
Excellent.
Very specific.
It's making us wonder.
Okay. We're starting to sort of get our target audience coming up here. If it's a footballer and balloons, probably maybe more male oriented, is it? I don't know. Okay, give us something else then.
Some wording maybe?
Yeah, on the front, like
Happy birthday.
happy birthday.
That's a good one.
With a number.
Eh?
could.
You are. It's normally.
You are here somewhere?
Well, no, like you're the age.
The number.
Oh, you want the, okay, what age would we have?
12.
Yeah.
Okay.
I would say 11.
You're going to have footballers on the front.
12. Depend on them, but that can sort of be changeable, can't it?
What about a spaceship?
Spaceship. Yeah.
Yeah, spaceship.
Spaceship. Right. One of them NASA images, do you think?
Yeah, go on, go for it.
I was thinking more 50s sort of.
And Rooney as well.
Yeah, really.
Yeah.
How do we draw a spaceship?
Terrible.
Draw NASA.
So we'd imagine that he possibly believes in alien abduction.
Well, I can see it in my head, but it's not quite coming out here.
You're not a big NASA fan, are you then?
Eh? I am actually. I am. Moon rocks.
Oh, like moon rocks.
Okay. Okay. Maybe that's enough for inside, eh? Or outside, rather. Inside's the most interesting part, isn't it? You know, you have this to grab somebody, and then but you always go inside to look what's inside, don't you, before you buy it, don't you? Are we happy with this?
All right.
Yeah?
Yeah.
I think it is. Okay. Let's go inside now. What we can do here is we need a verse, don't we? Maybe we can sort of collaborate on a verse. Maybe somebody can give me one line, and then we can get about 4 lines between us, and that might be useful. So give me one line.
On this special day.
Yeah.
Hope
Many.
everything is going your way.
Come. You can tell you work at a university.
Command the plane.
Two more lines, yeah, one more, 2 more. Doesn't have to rhyme. We can, you know, we are university people. We can be unrhyming. Anything.
Just to remind you, it's statistically unlikely that you will become a professional footballer.
You're not a school teacher, are you?
Football and a spaceship together.
Or an astronaut.
That it is very unlikely
That's a good present for birthday, isn't it?
that you will
Become a professional footballer. I used to coach football.
I noticed you said used to. Okay, we've got that. On this special day, I hope everything's going your way. Just to remind you, it is very unlikely that you will become a professional footballer. Maybe we could finish with one more line that's a wee bit more uplifted.
Yeah, but don't give up or something.
You can reach the stars.
But you can repeat.
Oh, yeah, they've got a spaceship.
Shall I
Give
put
up,
that?
there's always NASA.
What? There's always brain surgery. What do you want?
But you can reach the stars, as you
Yeah.
said.
Oh,
It's
right.
very
Yeah,
amazing.
that's a good one.
Yeah.
But you can still play. Okay, that's the verse done with. Now, what else do we want in our card?
Could we have could it play a tune? Could it play Happy Birthday when you're up?
Happy birthday tunes. Okay, we'll do
What
that.
about the matching date?
So it's mixed in.
That's a good idea. That one. Da, 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 da. Yeah.
The Japanese voice singing it. So. Just confusing.
Is this a cheap import?
What?
We got?
Match of the day tune song. Is it a? It's just a sort of instrumental, isn't it?
Mm.
Yeah.
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 Yeah. Happy with that? You don't want any words going in there or anything?
We are the champions.
It's not much today, is it?
No, but then you have copyright thing.
What?
Yeah, you will be.
The debating.
You're hoping that there's
Yeah.
so much music being played that the poor chap won't read the verse.
Personal.
Are we happy with da-da-da-da-da? Yeah? Mm. Yeah. So what else do we want on our inside page? We've got the verse and we've got the tune. And
We have a badge in there.
a badge.
A badge. 12 years old. Now you are 12.
That's just a thing that they can take off and
Just looks like an expensive car.
yeah.
Maybe a few stars.
Pardon?
A few stars.
A star.
Decorating.
Stars.
Just
Yeah.
coppers and money in it.
Stars. Yeah. Stars like that. Any ideas, Alma? Okay. Anything else? Are we happy with our card? Yeah? Because we have to get on. Okay. As quickly as that, we have created a copyright work. We've created a copyright work that gets protected under the Copyright Designs and Patents Act UK, which is this, which is my Bible, okay. Any advice or any copyright questions you ask me today is either come straight from this or my knowledge of some case law. But this is protected under that. In order to get protected under UK copyright law, it needs to be fixed in writing or otherwise, but it needs to be original. And by original, we mean basically the threshold in the UK is so low, except to talk about databases. The threshold for copyright in databases is a bit higher, but we're not talking about databases today. But generally, the copyright threshold in the UK is so low that when I say it has to be original, basically means we haven't copied it from anyone else. And indeed, we haven't. You could go into WH Smith's and find loads and loads, maybe of similar cards, even maybe the same, I don't know. But providing they've been created and fit that criteria of original work, they will get copyright protection under the UK. To get copyright protection, you don't even need to put the C in the circle. Under the Berne Convention, which requires no formalities mean you do not need to go anywhere and register your copyright work, and you do not need to have the C in the circle. It will get protected. Sometimes I say that because sometimes people still get confused about copyright if they don't see an ownership or a copyright circle. They think somehow there's a confusion and maybe it's in the public domain. No. And that's under the Berne Convention. There is another convention that the UK is a signatory to, and that's the UCC. The UCC does require the C in the circle. Most countries in the world are signed up to the Berne, but we're also, a lot of countries are also signed up to the UCC. Of course, it's silly not to put the C in the circle. That's good practice to do that, and it's good practice to put it against your own work, and it's good practice to acknowledge others' work, obviously, with a C in the circle. So we've created a copyright work, and when I talk about a copyright work, I mean the whole work. I'm talking about the work as a whole with our card. And just like any works that we may create at work, we put into those works what I might call third-party material. That might be material belongs to other people. So when somebody talks about third-party material, they generally mean material belonging to third parties, someone else. And this card is no different in that we have put in perhaps third-party content that we have now decided our card is so marketable that we need to clear that third-party content before we can exploit our card in any way we choose. And that's what we call clearing rights. We would clear the rights in the third-party content so that we can exploit the card within WH Smith's, which is you would call a retail sale, or you would maybe familiar, or your colleagues would be familiar in clearing rights to exploit maybe course material wider, even as far as the student would need a copyright clearance if you include third-party content to distribute it. Okay, so if our card is probably one of the best we've ever done in our heads, and we're going to exploit it, what third-party material, what material would you think you'd need to take care of so that we can get this card into WH Smith's? The typeface. Yeah, actually, the typeface is copyright, but generally, when we use the likes of a Word, Word and those things, there's sort of an enclosed license that allows you to use the typeface. But you're absolutely right, there is copyright in the typeface, there is copyright, and there's design right as well. So we'll assume we've got a license for the typeface because of the package we've bought. Okay? Anything else we would need to clear here?
Stolen NASA image. Maybe. Sorry.
So we're going to clear the NASA. Is anybody familiar with clear NASA images? Yeah? NASA themselves put the majority of it, because they're government funded, in the US, they put the majority of their materials in the public domain. And the public domain, they have a wider public domain in the US. If it's sort of funded by government stroke public money, they tend to shove all that stuff in the public domain. That means making it available to the public. It doesn't mean it's any way out of copyright. It could be in copyright. A lot of the NASA materials and stuff, you can actually exploit commercially. You actually can. You just need to acknowledge them. But if you get something from NASA, NASA's quite a few sites attached to NASA. You really need to read the license attached to the NASA images. But I've cleared quite a few images with NASA in terms of even being in touch with people astronauts and stuff. And they're actually very nice people to deal with. If there's any confusion in the license, you can fire off an email and they do come back relatively quickly and they're quite clear. But generally, yes, if we're not sure what the license says, we would go to people who perhaps are familiar with contract licensing and read it. But generally, you could be on a safe bet with using a NASA image. But you would just check. Anything else? Yeah, what about that? What do you think? Would we have to clear that? Would anybody familiar with Flickr? Yeah, yeah.
It depends. If the license says non-commercial, in any case, we need to get back to the creator and ask.
Yeah.
So it depends what the license is.
Yes.
If it says share alike, do whatever you want. There's no problem with that.
No.
But I would suggest to go back to the creator and say that we want to use it like that.
Yeah, it depends on the license. There's a lot of Creative Commons licenses on Flickr, and there's also a lot not. Lots of images now on Flickr, don't know if you've noticed, but they've said if you want to commercially exploit this image, please go to like Getty Images. the photographers have assigned their bargaining rights to big agencies now. And I think that's a shame somehow for Flickr. It seems to be more and more photographers in that way. However, there's still a lot of Creative Commons licenses on Flickr. And I'm going to ask you why you said tracing.
Well, it's just something I've come across, really.
Yeah.
And I just wondered how far the difference, how much the image has to be changed before it needs to have copyright, before you need to get permission. If you traced it really roughly, for example, would that be okay?
Not really. If it's recognisable from the original, irrespective of the license that you may have, which may allow you to do what you need to do. But if you've got a cartoon, say it's a Disney cartoon, and you put tracing paper and traced it and changed a couple of things, it's likely to be recognisable back to the original. The rule of thumb is in order to create a new copyright work, say you're using an image as inspiration, it has to be basically unrecognisable. So you would need to use it just for inspiration. But if you're tracing it, it's like a slavish copy because copyright protects a two-dimensional and three-dimensional representation. So even if you have a recipe and you baked a cake without having a license, because we assume when we have a recipe book, basically there's an inherent license there that allows you to bake the cake and do that. But basically that's an illustration of what, two-dimensional into three-dimensional. If you take that recipe and bake the cake, you're actually, on the face of it, infringing copyright, strangely enough. But yeah, no.
Happens when I bake.
Well, I might add, it doesn't happen when I bake either. I would be very much into the unrecognisable bit. But, yeah.
I've been thinking about this in the context of art.
Yeah.
For example, you can go and see an artist's work and clearly it's based on someone else's work. And there is a particular artist at the moment who is taking a lot of pictures from the internet and creating mosaics of the famous pictures. It could be a picture of a bush and with someone, some very famous pictures that are made, each pixel is made of another picture from the website, all over the place.
Yes.
Do you see what I mean?
Yes, absolutely.
So you can really recognize it's a famous picture, everyone has seen it in the papers.
Yeah.
And the images come from all around the internet, not necessarily copyright, not necessarily Creative Commons. So how does it work? Because this artist is there in the galleries, and so how does it work for art? Is it different? Or?
No, it works the same in that copyright subsists, and I'll show you the slides later. We'll rush through because we'll get on to the exercises. But copyright subsists in a work or a substantial part thereof. That basically says you can use small parts of any work. However, it's understanding what an insubstantial part of a work is, and sometimes that gets decided maybe in case law, and there's a few cases to do with that, and unfortunately I don't have time to go into them all. But sometimes for the like of me and Alma, we're using our depth of experience, shall I say, in what Alma would gauge what is insubstantial, taking small parts from all around the place, that she'd be happy to go on a risk basis on behalf of the Open University. And generally our risk factor in the OU is quite low, isn't it, Alma? So basically it comes with judgment and experience in how far you would take a work and use it, even if you took a work or quite a few works or pieces of a works and made a new work. There still could be somebody come after you and say you've used a substantial part of my work. And the area that's most common in is the music industry, where they use samples, and they've taken samples of music all over the place to create a new musical work. And there's been quite a few court cases about that. One in particular, which a long time ago, was Barry White, and there was like 2 notes. But this song got to #1, and that's why, if you could create a work and it might not create any problem whatsoever. But in the music industry, they did it, and it went to court, and Barry White had to be awarded substantial royalties because his notes were identifiable in this musical work. So basically, you need to tread carefully. When you're taking somebody else's work, even if you're adapting it, you need to tread carefully.
Do the works of art and music have the same copyright protection that text has?
Yeah,
it's
well,
100-year rule.
yeah. Oh, it's not 100 years, but I'll show you that, how much it is, yeah. Sometimes it comes down to just looking at an original and then looking at what you've created. And you've had to do that quite a few times, haven't you? Frequently, to decide what would be judged a copy. Because basically you shouldn't make use of someone else's work to just prevent you creating creating your own work. So basically, it just comes from judgment and experience. If we had something actual to talk about, we could dissect it, and we've had to do that and work with more or less texts that are being written and things like that. But generally, the rule of thumb is: am I creating something original here? I'm not just lazy that I've painted the substance of somebody else's work. And if you think logically, I've really taken the substance of somebody else's work, then I think you're into clearing.
Well, I suppose brands do it quite a lot, don't they? Tesco's cornflakes and Kellogg's cornflakes, the boxes look.
Yes, they do it.
In terms of that, just saying that probably is a good example, maybe in terms of the brands.
Yes.
I don't know. You know,
there has been. There's been with Coca-Cola and that sort of thing, where there's been quite where they place them together like that. But generally, other than the few that's been through the court cases, generally they seem to get away with having similarities, in the brands area. The main thing about the brands, ultimately, is they shouldn't trade on somebody else's brand, and they should be able to rely on their own brand. And yeah, a wee bit of competition along the way. Yes, that's a good point to do. Okay, we're just getting food for thought here. Let's carry on then, or we'll have... Okay, we've done that. Anything else on here? We'll move on to the second page, because I think the second page is quite interesting. What would we need to clear on this page? I suppose we'll agree we need to clear that music. And music actually is quite layered in terms of music. Every layer of music is capable of copyright protection. So you have the lyrics, you have the performer, and you have the composer, and you could have the recording. Now, in this one here, we probably have the recording, we probably have the composer, and we probably have the performers, the musicians playing here. And I will know that Match of the Day actually can prove quite difficult to clear, strangely enough. And there's more than one version. And I remember in our office, well, I'm early retired now, but in Alma's office, we have had a version of Match of the Day in our student material, which was fine because we had a blanket agreement to do that, linked to the BBC. But when we went to sell this course, we had to get that music taken out and another similar type version put in. And so we would need to, because that could be a blunt, stopping us now exploiting our card, because we didn't think of that. We just thought Match of the Day, it's everywhere. Oh, we'll have no problem clearing that. And then we find we can't clear it. So there's bodies that deal with music clearance, but my advice is you shouldn't really use commercial music in our everyday OERs and that sort of thing. There's audio networks, there's loads of what I call library music available on the net. Some of it available for free also. I know somebody told me that, if anybody's got experience of that. So you really should throw what's available on the net, or you can get like a royalty-free license for music from somebody like Audio Networks, and a lot of their music is the same as commercial music, if not better in some instances. But for some reason, if you do need commercial music, then you should be in touch with, well, MCPS, Mechanical Copyright Protection Society, look after what they call mechanical rights. That's actually the right to put music in a product. And the PRS and PPL, they look after the various interests of all those layers that I spoke about. So if you need to know anything about commercial music, you could ring up the MCPS, and they're very knowledgeable about music if that's an area that you think you need some advice on. But other than that, go with library music. Okay, what else now on here?
Is the copyright 70? Is it lifetime for 70 years or something?
After death, I'm going to show you that now. But yeah. So we'll quickly get on with the card. The badge. The badge, in a way, is an easy one, I think, because I think we would just have that manufactured, wouldn't we? We'd have that manufactured, and if we commission somebody, depending on how intricate the badge is and everything, we would do a commission and get copyright assigned to whoever, and go with that. Okay, so we've dealt with the rights on there. We're happy as Larry. We're going to go with a card. We're going to get it in W.H. Smith's. And whilst I said you don't need C in the circle on the card, we're obviously going to put C in the circle. Who owns the card? Who, or how many of us, whatever. Well, who do you think owns this card? Who's got the copyright in the card? You say the group. Do you think all of us who contributed? The group? Any other ideas?
You do.
You.
Me do. Mm-hmm. Bernie. Why would Bernie own it?
You translated it.
You mean I?
You wrote it all down. You designed it. You put it together.
Heaven help us, eh? Any other ideas?
Not shared copyright. If you clear the copyright with these other things,
Yeah.
like your copyright and also their copyright.
Who's there? You mean the licensors?
Yeah.
Okay, we'll put that. Okay. All right, that's very good. We'll rush on.
Sorry, so what did you? Publisher.
The publisher. Okay. All right. In the first instance, in the absence of any contract, the author is the first owner of copyright. The author is me, as you rightly said, because there's no copyright on ideas. You all gave me loads of ideas. We didn't have a contract. I've ripped you off and all those wonderful ideas. And this does happen, actually. It happens. I've had it in my working career happen quite a lot, particularly in collaborations, where people are so enthusiastic about the collaboration that they actually don't sit down and talk about copyright and who owns it and get it all. So it's useful from that point of view to make sure you have those copyright issues sorted at the beginning and then get on with your work and who owns what. The group is also a good idea, but we didn't have a contract. Copyright wouldn't rest in a group per se, because copyright has to rest with a legal entity. That means I can be taken to court, but a group, it's like saying the Open University Research Group, wouldn't necessarily be the legal entity or owner of copyright. That would belong to the Open University. And that's useful to know as well on your institutions. I know on a few occasions we've had to deal with maybe the library, putting a C in a circle, the Open University Library, and we've had to say diplomatically that the copyright rests with the Open University, although you would credit the library, you would say developed by the Open University Library for the Open University, and give them as much credit as they need. But that C in the circle would be the Open University. Okay, I won't dwell on that too much. There's so many other things we can go into to do with copyright and ownership, employee, employer, and all the rest of it. But we won't go into that because we want to get on. Now, our poem. I know I own the copyright in the card. Do I also own the copyright in that poem?
If it's a written one.
Hmm? What?
If anybody else would something like that.
You're welcome. You're welcome to it. What do you think? Do I also own this copyright in the poem because I put it down?
It's not the same as the ideas thing.
Is it? Yeah. It's good to say that because this is not an idea. You actually didn't give me an idea about the poem. You actually gave me verbatim words, and all I did was record your words on here. So the copyright in this poem doesn't belong to me. It belongs to everybody who contributed to it. And in that sort of situation, it's probably multiple copyright owner. So yeah, you're like Barry White. Yeah. I've noticed there's my line of poetry on there and I want my royalties. It could be that one line wouldn't be capable of copyright protection on its own because it would be considered perhaps too small. But altogether, most certainly, it would be copyright protection. So we would have, how many authors? 4 authors on that. That would be a joint copyright situation. So we'd have to agree on that. So, okay, that's that. We'll leave that for now. That's just to introduce you to copyright, and we'll move on to our slides, whereas I'll quickly go through these as well. And then what I want to do is actually give you some exercises where you can, and then we can chat about those after, because I think they're most useful, particularly to do with Creative Commons, if that's all right, and we can start talking about those issues. Now this is what, can you see this okay if with me sitting here? Yeah? Okay, that's just what we went over there. No registration system, no quality threshold. It's owned by me and the author in the first instance, and it represents control over what they call restricted acts. This is all the types of works that's protected by copyright in the Copyright Designs and in Patents Act. And the UK is actually one of the most comprehensive copyright acts. It actually, when everything went online and digital, the UK Act had already all that covered by the wording. So while some countries weren't, the UK was. So it covers everything, as you can see, tables, compilations, computer programs, scripts, mime, everything there. Also film, sound recordings, broadcasts, typographical arrangements, somebody mentioned, performances and databases. Now this is how long a copyright work lasts. It lasts 70 years after the death of the author, which I think you were sort of familiar with. At least you knew it was a long time. Broadcast sound recordings and performances are 50 years. However, that's all going to be changed. That's also going up to 70 years. It's just been a directive. But it'll probably come into force in the UK in the next 2 years.
Is that because of is it Cliff Richard that's being...
Don't start Alma on Cliff Richard. She hates him. But basically, yes, there's been a lot of lobbying, and as Alma would say, on the likes of Cliff Richard, who's never wrote a song or anything, he's only got his performances.
He actually said he was talentless.
He said well, I tell you, yesterday I had my Cliff Richard t-shirt on, because I've been to quite a few of his concerts. I'm not ashamed to say that. Okay. Yes, a lot of lobbying going on, even the Beatles. And that's why when it gets near the end of the recording, 50 years, that they bring out these re-compilations and all of that to churn out more money.
Why does it need to be after the person's dead?
Well, well, this 70 years, this 50 years for the recordings and performances, that isn't after the person's dead. That's from it was first broadcast, recorded, and made available to the public. But this, after the owner's death, 70 years for literary, dramatic, musical, and artistic works, is 70 years after the author's death, is because it's supposed to look after at least another generation, in terms of, bequeaths and that sort of thing, So that's the theory behind it.
Sorry, you mentioned the law in the UK, but if the law is different in different countries, how does it work?
Well, this is the law in the UK, but our copyright works are protected worldwide anyway, through the Berne Convention, through the UCC, through various conventions. That's how our works get protected worldwide. So if they're infringed in another country, they're infringed under they're protected under another country copyright law. So they would be infringed in their country. Our works are protected under their laws, under foreign laws, under copyright, and through various agreements and things like that.
So what does it depend on the nationality? Let's say that Cliff Richard records something in another country.
Yeah.
So how does it work in terms of, is
Well,
it under the UK law, under that country's law?
Yeah, it's under that country's law.
Right.
But it would also get, he would come back and release it under this country's law, it gets protected also. So it makes sense that your copyright work is protected worldwide.
Can I ask something? Is there in country no part of any convention or agreement?
Well, not that I'm aware of. There's a few countries, I couldn't even list them, that are, there's a few countries in the agreements that perhaps don't abide by them as well as they should. China might be one. But I think but generally most of the world, most of the developed world have a copyright law, and they're all signed up to the Berne UCC convention, and even America. So yeah. Okay. This is just letting you know that the authors for film sometimes is considered a wee bit different. Like the director would be considered an author, the author of the screenplay, the author of the dialogue, and the composer of the original soundtrack. Those four authors would be deemed authors of a film. However, if you were clearing footage to have some clips and whatever you're producing, in a way you don't need to worry about that, because you go to a film company who owns the footage, and you would clear the footage that way. But that's when it would expire, after those four authors have died. When it says restricted acts, this is basically letting us know that this is what we can't do without permission from the copyright owner. You can't copy, you can't issue copies to the public, perform, broadcasting, you can't adapt, which we were talking a wee while ago about adapting in all those different guises that we spoke about. And adapting also means putting a translation into another language, also in computer terms, translating that from one computer language to another. That's all under adapting. Storing an electronic medium and altering and overriding security systems. Rental or lending, this is basically to do with piracy and that sort of thing, except for authorising infringement, which could do with the internet and how you put works on the internet and that sort of thing. But we haven't got time, unfortunately, to go into all the ins and outs of everything here today. Permitted acts, insubstantial use is not in the Act, but we put it there just to remind us to say that you can use small parts without infringing copyright, but you just need to be careful that you don't use too much, because insubstantial is qualitative as well as quantitative. So if you said, Alma Hales did it in the library and she used a knife, that would be considered quite substantial, because it could be the whole whodunit in a book. So when I said you shouldn't take a substance of anyone's work, that's what I mean as well. You shouldn't take the substance of anyone's work, not just the amount, but the actual sort of whodunit. And this is non-commercial research or private study, purposes of criticism review, fair dealing for the purposes of reporting current events, bona fide examinations, and instruction in filmmaking. Sometimes we can spend a lot of time, Alma and I, going through these, but we don't have time. But basically that's what you can do. If you've got any questions or anything later on, you can just fire them at me. And this is to do with licensed recording of broadcast educational establishments, which is the ERA license and the CLA license, and you can record at home your favourite programmes and watch them at a time suited to you, but you're not supposed to collect a library, that sort of thing. Like we don't. Decompilation has to do with software, and you do that with caution. And redrawing, you do that with caution, which is what we spoke about. Redrawing a slavish copy and that sort of thing. There's no copyright in information, so you can look at information, take that information and present it in your own way. That is creating a new copyright work. So you can look at information, say, on a table, and then make a pie chart and source that original information, because you are creating a new copyright work. Translating, you cannot do. When you translate a work, basically you have created a new copyright work, but you can't do anything with it because you haven't got the permission to translate. So you could put a lot of effort into translating an original work, but if the copyright holder is still alive in the original work in which you translated, you would be infringing, distributing it, and copying it. But you would have created a new copyright work of which you would be entitled to copyright protection, strangely enough. In other countries, they wouldn't allow you to copyright protection in a work where you wouldn't when you haven't had permission in the first place to translate it. But yeah. This is sort of a thought process that, strangely enough, I use when I'm dealing with copyright every day. You know, it just goes through my head. If I'm asked a question on copyright, it just goes through my head. Is it a work? Is it protected? Am I performing a restricted act? Is what you want me to do a restricted act? Do you have a defence? And that's all those defences that I showed you, a criticism or review and that sort of thing. And if no, yes, no, yes, well, you use it or you clear it. And okay, Creative Commons. I'll go through this and then I'm going to have you do a wee exercise. Why choose Creative Commons? Well, Creative Commons, as I said, is not a religious movement or anything like that. Creative Commons is a license. It's a license that basically Creative Commons, the organisation, got together and created these licenses because they recognise, first of all, that people get confused reading a lot of legal language in contracts. And they do recognise also that there are many rights owners out there do want to make their works available, but they also want to retain copyright, and they want to make them available in a way that, say, suits certain communities. And they've got a suite of licenses that they can choose which one that they may want to use to put their works out in, available to the public. Of course, it displays a mark of commitment, and standardised terms, as I just said, so easily understood. If any of you are familiar with Creative Commons licenses, so written in just plain English, and they have a legal code that's written for lawyers, and then they have this sort of easy to understand language that says you can do A, B, C, and D, and easy peasy. And when I say standardised terms, easily understood, also the symbols in Creative Commons are internationally understood. So if you were even searching for content under Creative Commons license and you found a Creative Commons license that was written in a foreign language, because the symbols are international, you know straight away, if you become familiar with those symbols, what those symbols allow you to do. And even if you don't, as I've done sometimes, I've gone back to my English version of Creative Commons and was able to just say, God, I can do A, B, C, and D. It's so easily understood, those terms. Of course, as I said, based on collaboration and interchange, which is what open educational resources is all about. And the moral rights are preserved, and copyright, of course, is preserved. Creative Commons, attribution of authorship is something you have to do in every Creative Commons license, no matter how restricted or wide the license is. The most fundamental part of a Creative Commons license is you must attribute the author who's attached that Creative Commons license to his or her work. This is sort of looking at how you would choose perhaps to make your works available under Creative Commons license, and some considerations you may apply. Whether you want people who use your content to vary it or no variation of content, you can choose an appropriate license for that. Whether you want them to use it commercially or non-commercially, and whether you would like any future use to be licensed on same terms and like what they call a share-alike license. And as I said before, it's internationally recognized symbols.
Can I just ask, who owns Creative Commons? Who's behind it?
Well, I'm not sure who owns it now, but it's a whole organization that started up from academics in Harvard / Berkman in Harvard. And they obviously got together and wanted everybody to collaborate in sharing content. And for years they'd been lobbying to get people to share content, much in the same way that any of you familiar with software, you would have had those software licenses that originally were put out under a share type license, so that if there were any bugs in the software, that they could be corrected and then put back to be used appropriately. And it sort of spun off that in terms of, but I can't remember the guy who now, Lawrence Lessig was a big name. And I actually went on I did some of my training at Harvard, at Berkman, under Lawrence Lessig. Years ago, when the internet was sort of new, I went to Harvard for one of them residential courses. I thought it was fantastic, yeah. But the Creative Commons hadn't come in then, but he was espousing about he wanted content. And we used to say, yeah, but you write loads of books, Lawrence. You're not putting any of your content out there for free. But no, it is. I don't know who runs it now. I know Lawrence Lessig still has a hand in it, and he was sort of, him and others, because they were lawyers, sort of pushed it ahead. And it's so. I think it's a wonderful license. Okay. This is basically just things as well, if you're dealing with Creative Commons or you're dealing with putting your content available wider to the public, that basically you should be considering. How you deal with ownership of content created in-house, whether it sort of falls under terms of employment or not. Moral rights, dealing with licensing third-party content, if that's an issue. And what sort of business model, and what is non-commercial. Obviously based on collaboration and creation and publication of content by users. These are just things for consideration. And maybe some of the exercises that I'm going to give you will bring out some more issues. But with the Creative Commons, copyright is retained. You get a broad licensing of tools and content. You've got standardized licensing, and it is very much community-based. Okay, well, I'll leave that up there because I really do want to get onto the exercises. Creative Commons, it is based on copyright, as I said. It does not protect the ideas or facts. It applies to all works. Fair dealing, fair use preserved. It's non-exclusive, it's non-revocable, and I just say, think about what you are licensing. Okay. I'm going to hand out some exercises now. Right. This is not, we're not going to come up with a sort of a right and a wrong answer. You know, there might be situations where whatever you say is good. It's just that you've considered all the issues to hand, and that's fine. Okay, you find 6 images on the web, and you use them in your course-related DVD. The resolutions are fine. They are available under Creative Commons Attribution Non-Commercial License. This clearance is fine for your initial use for your staff and your students. but you probably eventually hope to sell the course. Should you not bother with those images and reselect? What did our group here think?
Reselect.
You would reselect. Would everybody reselect? Why would you reselect?
Costs.
Costs.
Cost implications of actually having to change the images for commercial distribution.
Well, you can always ask.
Well, that's fine. I mean, the reason I put this question is because I deal with this sort of thing all the time. Because I do clear copyright works for open, closed, you name it, I've done it. And in my experience, and it's only my experience, I wouldn't have reselected. Because you find, and I found from my experience, that when I've gone back to the rights owners, they have actually, without exception, given me permission for no charge. So it's just a consideration. So whatever business model you're following, it's just don't sort of jump to the next scenario and think, oh, we need commercial, this is a non-commercial license, because it's just a license that the rights owner have made available. But it's likely they could be very willing to just, because your commercial activity might not be commercial in the true sense. You might be making money, maybe within an educational institution, but it might not amount to a profit that's going to make, and if there are any profits, it might be they're going to be plowed back into your educational institutions. So there's all those things to consider, and those things that you consider is how you would approach a rights owner then, and say, look, I've got permission, and say you've got the Creative Commons license from Flickr. It's an image, it's from Flickr. For those of you that are familiar with Flickr, you can email them through the Flickr site and get them to email you back. And quite often when I email through Flickr, I give them my institutional email then, and I say, can you come back to me? Without exception, I must add, there hasn't been loads of cases, but without exception, it hasn't cost me any more money. So it's just a consideration. It may be whatever factors come into play, you might think, no, we have to ditch those images, but you've already got them, you know.
What's the worst case scenario though? If you did take them and they were particularly nasty with the owner, and you did make quite a bit of money out of it, could they come down really hard on you? Could they really sue you?
No, because what I would say is when you negotiate with a rights owner, obviously you're an honest people. You're not telling them lies, and you could make loads of money, but still, if the situation is, the money's going to be ploughed back for the educational purposes of that institution. You explain that, or you explain something about your institution and how, you know, the Open University is a very good case, and I always talk about widening participation. That's why we want to make it available. In this instance, we're going to sell it, but any profits we're going to get plowed back to the institution. And
you'd always ask them first. You make sure that you would ask them. Especially if you found those images on the internet and you couldn't work out who owned them. But would you just like take a chance, or would you leave it?
Well, yeah, I mean, it depends on, for a start, no institution or any business operates without a risk factor. And you have to have a level of risk. If you don't have any level of risk that's acceptable to your institution, you're not running any business whatsoever. And depending on your business, you can't be two jobs worth. And particularly when you're dealing with copyright, obviously I try to share my experience with you and try to make you more confident in dealing with copyright in the sessions that Alma and I do, which last a whole day. So we want people to go away and feel more confident in dealing with copyright so that they can make a decision and then move on. And to make a decision to say, oh, we're not using that because we haven't cleared copyright, could be the right one, but you need to make it at the right time so that then you can carry on and get new content in. So basically, you got to make a decision. You got to plan for your copyright clearances. You got to plan to allow you to clear it or get a refusal, insert new content and decide which content that you would go with if you don't get a response. And that would be within your risk considerations. And there might be some stuff you decide you're most definitely not using, like a Disney cartoon. There might be some high-profile stuff that you say we're most definitely not using that on a risk factor. Not that you might get a refusal, but you also, it might be too expensive. And those factors come into play when you're making those sort of decisions. But on the net, if you come across images, and maybe you're doing an image search, there could be loads of the same image, and perhaps you cannot trace back to who owns it. And depending on the image, that might be a relatively low risk, and you would cover it by saying that you've made every effort. That's not a defense in any means. It just shows that you follow good practice. And then, because the rights owner, as I said, is control, the rights owner can say, I don't want you to use it at all. In most instances, and with experience, you realise that's not the case. You know.
You'd be surprised. I've had an instance just today whereby a course team have made a selection of audiovisual content for OpenLearn. So it's going to be available under a Creative Commons license, and I've had to say, you're not using chunks of it. Take it out, take it out, take it out.
And I think we've got that in one of our questions, that sort of thing.
Yeah. So the experienced people and experienced producers put this together, but they still hadn't thought, gosh, it's going to be open, and the decisions I might make for a closed area are to a certain extent different to the decisions ultimately made and the risks associated with an open area. And this video clip included children, so I was doubly careful.
Yeah. So we'll deal with that question I asked about children. In terms of when you're dealing with copyright as well, it's not about, in many instances, what you've got the right to do. It's about doing the right thing in some things, and ethics does come into play in making content open to everyone. And I'm sure your institutions will have some policy on ethics that sort of gives you guidelines on whether you've got a permission or not. We do not do A, B, C, or D, whatever. So let's look at that one. We're promoting a course on the social care and well-being of children in the 21st century. You have a cracking photo of a group of children and another of a young child, both of which you got from Flickr. What's more, they are available under Creative Commons Commercial Share Alike license. You intend to use these images in your printed material and online marketing for the course, and you want to distribute to also your usual outlets of child and news agencies, etc. You've been asked to ensure you have permission for use of the images before you print them. But if you have a bona fide Creative Commons license on the Flickr side, do you need to consider anything else? What did you decide? What did you come up with on that one?
We said you need to consider the people that are actually being photographed, and you're not sure whether they've given permission for their image to be used. So we just suggest not using it.
I think we were looking at the scenario on this rather than that one. Number 2 talks about children.
Those are the same issues that we talked about.
Yeah, same kind of issues.
Yeah.
But, that one's actually slightly different because this one we just said no.
Yeah.
Was the one you
even with the Creative Commons license that you've got on this, I think you still can't guarantee that the subjects of the pictures have given them permission.
I think you saw. What did anyone else think? What did you say down the bottom?
Similar, wasn't it?
Mm-hmm. Yeah.
We were concerned about whether the participants had given them permission, and whether someone uploading and licensing content was enough, which is.
Yeah. I think you just have to have your own quality gauge yourself. The images of children could be suitable for online, open, whatever. They could be so like a nothing, you know. They could be profiles. They could be the images of the children are fine, but you really need to be careful whether you've got a license or not. Full face images, and Alma, you had an instance today of children that, in a way, were about children being sexualized.
Yes.
Weren't they? That was, and you rightly, I think, said no way.
The original use was fine.
The original use was fine, and it's a subject that needs debated and everything. But the images themselves, if you can imagine, and the pageants and things that take place, Alma thought that no way would she allow them to go on an open website, although the subject matter could still be debated, but then they could have to be very careful in how they choose the images, Alma was telling me. So it's just be careful whether you've got a license or not. As I say, just have your own gauge of quality.
In that instance, would you sort of say, well, instead of having the actual image within your material, put a link in to say the sort of image we're talking about is available here, or is that still, you know, so you're not actually having the printed image in with your text?
I would.
Or you wouldn't even do a link?
No.
That's just a personal...
Yeah, I think you just need to be careful. And what we're talking about here is paedophiles, aren't we? We don't want to be a shop for paedophiles. And paedophiles, you know, we don't know how they operate, and that's why Alma is ultra careful, and I'm ultra careful when I'm dealing with open, because even a full face image can be taken as sexual. If you can imagine those grown-up images of models and things, they focus on the face. So we always advise profiles is fine. If they're looking at an activity around a desk, sometimes you don't need more than their hands. You have to, if you're thinking about the children and the children's images and against your brand online, it really lets you focus on actually what do you need, and not just what have we the right to do. Say, well, actually, we don't need that. We can do with this, and it just allows you to focus, I think. So you've been very good at that. So the second question on this one again was a lovely image of while he was on holiday. Did you have a different response to that? The same response, or you mentioned that, didn't you? Yeah, we listened. Yeah, that was an actual thing. Actually, that actually happened, didn't it? Yeah. And yeah.
We had a question about that. We wondered if the children were sort of off focus in the foreground, and you're actually taking the castle in the background. You know, whether that would be okay, or whether it was because the focus of the image was children.
Yeah.
In which case we weren't happy.
Yeah, you might not be happy, and if you've got a few images, you might get one out of it where you are happy with. And this actually happened that an academic did go on holiday, and I says, but how did you get the image of all these children in their school uniforms? Oh, I just gathered them all together. I says, what about the permissions? He said, yeah, they were happy with it. Honestly, that's true. I said, no, not using it.
As a child, can they give permission?
No.
They can't. And in the Scout Association, of which I'm a member, if we want to, on our permission slips, when they do an activity, every year the parent has to say that they have no objection to photographs being taken, and we have to put on it that the photograph will only be used for Scout Association purposes and not for any other activity or game. And if there is going to be any commercial use made of that, because sometimes we have had the Scout Association promotional people come down to take photos and videos and stuff, they have to get permission particularly from those parents of the children they're going to use. So it may be that they take the video, but then they have to go back to each parent that's in, you know, of the children that are there to get permission. If that parent says no, they can't use it.
Yeah, I think it's one area to do with all our children that we can be jobs worth, and we can really, and we work, I mean, Alma, you work quite easily with it. Doesn't create a problem.
Copyright's never a problem.
No.
I know that sounds very weird to say, but if it's set up properly, it isn't a problem. And third-party content adds a richness to resources, unquestionably. So for me, it's not a problem. I don't like it being used as a barrier.
Yeah, no. So that's good. Okay, number 3. You find an article by Alma Hales on the web, and this will be brilliant for your learning object intended for open use. You contacted Ms. Hales twice, and you've been in touch with the webmaster, see if she can help, but no response. You've amended it because you didn't agree with some of the points she was making. No, I don't either sometimes. And you think you've improved the work. You've obviously left her acknowledged as the author. You've had no response, and you're just going to use it anyway. And everyone's always talking about taking a risk, so you'll take this one. And is that okay? Our bottom group. Yeah, what did you think?
Didn't think it was academic good practice, because we were a bit confused over what exactly we're attributing to one author and what you were attributing to yourself. And we felt that it might be appropriate to use it, but you would need to write it up, not actually just changing the content, but showing what the original content was, and then indicating what changes you felt ought to be made to it, as you would in any piece of academic work.
So you would perhaps, from an academic perspective, you might change it, but not really change it substantially.
No,
is that what you mean?
Maybe
Maybe
to change it. I mean, you could actually link out to the original article in its location, and say, "I'd like to draw your attention to the following aspects. Other research has indicated that this might not be, you know."
Yeah. Okay, that seems a good alternative, doesn't it?
Well, I think a common practice is also to say adapted from, and you say where you, because we adapt materials all the time, and we simplify text. This is the way we present it.
Yeah.
So adapted from, and you give the original reference.
Yeah. And you would link. Would you also? You would
No.
link. You would use it.
You would use it, but you give the reference so people can go and find.
Okay. Yeah.
Yeah, if you give the full reference to them.
But would you change it? Would you change the word?
Well, when you adapt it, you change it, you simplify the language, or you even change it, sometimes the structure, or you add a picture that wasn't there.
Yeah.
So we do that in our materials.
That's interesting, isn't it?
And you say it's on the web, but you haven't said whether or not it's a wiki. And if it's a wiki, you can edit it anyway, can't you?
Yeah. Oh, well, it must be a wiki then if you're editing it.
So, if I've got this bit of paper and it's on the internet, and you add 2 pictures and a paragraph, and you just take that second paragraph out, you would use that and just say adapted from blah 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 blah. You wouldn't think actually Alma might object to me adding 2 photographs.
You have to ask for permission first to the author. But again, if the author doesn't respond,
right,
we always ask for permission.
Right. Okay. So you wouldn't just go ahead and
no, you need it.
But if the author didn't
respond. You go ahead and do it.
Would that be?
Yes.
How long can you? How many? We were saying, like, what if the author went to live in a cave, right? and you couldn't get hold of them? How many times can you ask them before you can just say, "Oh, I'm going to use it anyway"?
Well, I suppose saying, "Oh, I'm going to use it anyway," isn't the right response, but you would have a process where you would seek permission, and then you would gauge whether or not, as we spoke before, whether or not you'd be willing to take the risk and use it on the basis that probably Alma's on holiday in a cave, and the nature of the material as such is likely to give us permission if she only knew we wanted it. So maybe using it is a relatively small risk depending on the content, as we spoke about. Maybe adapting it raises the risk a wee bit, but then you're going on your experience and what you've done, and that is a good gauge as well. All the experience you have and the nature of those adaptations then may hold. There could be the odd thing comes out to bite you in terms of Mrs. Hales might not be happy with the adaptation, but maybe that adaptation is just for the purposes of your readers and it's not taking away the context of Alma's work, so that might be okay. There's just various factors to consider, and as long as you consider them, then that's fine. Okay, your institution has an online open learning resource and it's based in the UK. You've selected an England and Wales UK licence for the use of your content. However, you've been asked by a user in China if the CC licence still applied. Does the CC licence refer to where the content is being hosted or where it is hosted? I don't quite get that.
Content
Oh,
is
used.
being
Oh,
used.
used. Sorry. Yeah, used or where it is hosted. Okay. Is this one group? And group down here, what did you think?
We're in the same group.
Oh, you're all same group.
Well, yeah, I think this is one we were umming and ahhing about, actually, because while obviously the CC licence is international, we were a bit unsure because the statement that the English and Wales UK licence had been actually adopted. So that's something that we hadn't really come to a conclusion about, because we were, you know, on the fence in the sense of saying on one side yes, because it is an internationally known thing, but yeah, on the other side not entirely sure. So sorry, it was a bit
I
cop
think that's
out.
a good response, recognising that the CC licence is international. What did others think? What did you guys think over here?
We were a little bit unclear about whether you'd licensed it under CC in the first place, because you specifically said England and Wales, which would that refer to the Patents and Copyright Act, and so would be a different.
Well, this is contract in a way. This is like contract, and UK and Wales is like a jurisdiction. So
I think in that case we'd say the licence still applies wherever it's being used.
Yeah.
It's an
What?
international agreement.
Yeah. It is an international licence, and as we spoke about earlier, about recognising those symbols, even if it's written in a foreign language, the principles of Creative Commons applies internationally. However, you do have these different territorial jurisdiction licence, and they're called ported and unported. A ported licence is where they put the Creative Commons, it's written to fit a particular territory's law and copyright terms. So the UK licence in Wales is written to take account of, say, a database right that we have in the UK but they might not have in another country. It's just a language and nuance thing that may apply in different territories. However, the licence is international. If that licence was breached and needed to go to court, the UK would be the jurisdiction, because that's what it says. Quite often you see it in software licenses, don't you? When we've got that free software, they would say this is under California law and that sort of thing. And so...
Is there a difference between an England and Wales UK licence and one that would include Northern Ireland and Scotland?
I don't know. The principles are still the same. In Scotland, they have the license is basically the same in copyright, but in Scotland they have a different law in particular areas of the law to do with children, different case law and that sort of thing. And Northern Ireland, they probably have the different nuances as well. But generally, in terms of Creative Commons, it doesn't present a problem. It's just what it is. It's an ownership thing as well. If Scotland want their own licence, it's because Scotland want their own licence. Are you with me? Yeah. Well, I'll Scottish.
I am indeed.
And I'm from Northern Ireland and haven't put too much thought into it in that respect.
So actually, it's where it's hosted, or where it's created, or it's being used. So it's being used.
Yeah. Yeah.
Where it's being used.
Where it's been used. Yeah. Okay, you have some software and you'd like to make this available under a CC license. Would that be okay?
We thought it's not suitable.
No.
Yeah.
It's going to be licenses.
Yeah.
Should look at the Free Software Foundations.
Yes, absolutely. That's really good for those of you that are interested in software, because people do get confused about Creative Commons. They think it applies to everything. And of course, they might apply it to software and that sort of thing, but it's because of the language and deals in source code and object code. The language isn't really written in a Creative Commons license to take care of software, whereas, as you rightly said, the Free Foundation and the GNU and whatever is out there looks after software much better. So that's right.
Creative Commons as a body looking into software, Bernie?
Well, I don't...
I vaguely remember reading that. They were looking into...
Well, they might do, and in a way it could be useful if they make it simplified, because have you ever read those software GNU licenses, and they are quite complex, aren't they? Yeah. Once I had to get in touch with somebody, I couldn't understand. I thought some of the clauses, some of them contradicted each other, and because there's loads of them. So if anybody was simplifying the whole, you may do and not do, and share and not share in a way that Creative Commons is written, I think it would be welcome, wouldn't you?
Yeah.
Yeah. Yeah. Did you read something about that then?
I thought I did recently, but...
Yeah. But I mean, Creative Commons themselves advise you to look at GPL and GNU on their site. So I don't know. Okay, that is good. So your institution is making some of its content available under a Creative Commons license. How do you ensure that your trademarks and your logos are protected? Let's see, the bottom.
Well, it's the questions of material, because your license is for the content, not for your trademarks and things like that.
What did the rest of you think?
Well, that was what I thought. I don't know what the rest of the group
If it's a trademark, is it not automatically protected?
By Creative Commons or
no, by the trademark.
Yeah. What did you think?
You have to register your trademark.
Yeah. Do you know, you are the first group to say that, which is perfect, because it does cause some confusion that when you put your content up, and obviously you have it with your logos and your trademarks, people think, they're going to use our trademarks and logos under Creative Commons license. No, Creative Commons license does not protect trademarks and logos. Creative Commons license protects copyright works, and they have their own protection, as you very rightly said, and I'm so pleased. However, in order to erase that confusion even further, in all your terms and conditions, it is useful to reinforce that your trademarks and your logos, etc., is not made available under the Creative Commons license, because lots of people are confused, even though yous aren't, and I'm so pleased about that. I think yous have done absolutely brilliant. Yeah, and if you've got any burning questions before...
I do have a question about, I'm in a project where we have a project website, and we wanted to apply the Creative Commons license on the website, so all the things, all the resources, so anything that we put up, even the images, are Creative Commons. But people have concerns, so I don't know what it would be the standard practice if you are in a project. It's a JISC project as well, whether you can place the Creative Commons on the website and it should be fine.
It's a JISC project, and the requirement under JISC, they're funding it, is that the content goes up under Creative Commons? Or...
I'm not sure. I have to check.
Well, the first thing is...
Well, the project is about open education resources, so the idea
so
is...
it's likely that... So on the face of it, the Creative Commons license would best serve that project. Now, which Creative Commons license, I don't know. As you know, there's 6 of them, so you need to choose the right license. Share alike might be a good one for you. Yeah. So what is the problem in doing that? Are you talking about the content belonging to your institution?
I do not see any problems, but colleagues are very nervous about it and say, how do we want to put this up? Or, you see what I mean? There's a lot of uncertainty. What is the usual practice in this kind of projects? Do people put it?
Yes, they do. And those projects they would put them up under a Creative Commons. The most type of license, like the Open University use, is a non-commercial share-alike license. Now, your terms and conditions should allow for exceptions to that, because there may be some content not suitable for a share-alike license. You may want some content available under a non-derivative license, because it's really not suitable to be adapted, changed, improved, whatever, depending on what the content is. So any terms and conditions should be flexible to allow you to put it up under the terms and conditions that's suitable for the content. if it's a project where the authors are putting content up, then you could ask them to put it up and it's going to be used under Creative Commons Share Alike license. However, I know there's some projects at the Open University where the authors are allowed to choose which Creative Commons license they're allowed to put the content up. So there's a flexibility. And I mean, my job here this afternoon is to make you think widely about Creative Commons and not just think one size has to fit all, because you have to choose the licenses or license appropriate to your project. And I know in Open Learn that Alma looks after, we have got the Open University material under a Share Alike license. We've got third-party material up there not available under a Creative Commons license at all, and then within that we might put some sensitive material up that we do not make available under a Creative Commons license either. So everything is sort of monitored and it's put up under appropriate license. However, most of it is put up under a Share Alike license. Sometimes we've put it up under a non-derivative license, haven't we, Alma? Yeah. And we have, when we put the content up, we would say to the users, this content is made available under this particular type of license, and we make sure that people are aware of that.
So the license is a consideration. I think it's unhelpful when you start getting into conversations whereby the contract is king. It's still all about the content.
Yeah.
And it's very easy to get into the licensing conversations and actually think the content should be king.
Yeah.
And you do what you can with that. But if your starting position is, what license shall we pick? That's a shame.
Yeah. Yeah. You pick appropriately for your users, for your content, and I just advise you to think widely for your project, so that you're not, even if some say, oh, this needs to go up under a Share Alike license, maybe it does, but why? You know, and it widens the content. Once you sort of widen maybe the type of license you can apply, even if it's kept under Creative Commons, and I think Creative Commons is brilliant, it just widens how you're making this available to your users.
And I think when everybody gets GIST funding these days, so you work on a GIST project, and the OU is certainly obviously no different, but I never ever relinquish copyright for existing OU materials to a project.
No.
Ever.
And I don't even think GIST requires you to do that now. I think years ago perhaps that might have been the case. But the fundamental thing about Creative Commons anyway is that Creative Commons is a non-exclusive license. I think I mentioned that. That means if you're the rights owner or your institution's the rights owner and put material up under Creative Commons license, that's the license you're making it available. You own the material, you can do what you like with it. It doesn't restrict you to using it under a Creative Commons license. You're just allowing others to use it under whatever Creative Commons license you've chosen, but you can do what you like with it. Creative Commons license is non-revocable. That means when you put it up under the Creative Commons terms and conditions, then you cannot revoke that license. You can take your content down, you can stop making it available under a Creative Commons license, but what you can't do is revoke the license to those people that you've already made it available under. They can continue using it under the terms, under the Creative Commons license.
Can I ask something based on that? Let's say we're taking material from Flickr and some photographs, and all of a sudden the creator decides to revoke the license and makes it probably non-derivative. What happens to our content?
Well, if you've already used the content under the first license, which was Share Alike, perhaps, I don't know, then you can continue using it under a Share Alike license. However, I think you must consider when they put the material available under Share Alike license, was it really appropriate? Because some people put stuff under Share Alike license and Flickr, and it's not really appropriate for a Share Alike license. Perhaps, in their view, it could be artwork or a photograph, where photographers are quite keen that the quality and the context of their artwork remains intact. So it could be he or she's realised this and then
decides to
put it under under a non-derivative license. So depending how important that is to your project, then you do have the right to carry on using it under your share-alike license. But I think then you should consider, well, really this image isn't really appropriate for a share-alike license, and maybe I can also change the license to a non-derivative license, you know. Just something to be considered. But you still have the right, it's non-revocable, that license that you've had originally.
So, just to be clear, if you issue something you made under a non-commercial license, you can still make money off it if you want to.
You can. Yes, you can, because yes, other people can. That's absolutely right. You're the rights owner. You are in control. You have licensed it under a non-commercial term for others so that they can't make money of it. But as I say, if they come back and say, we're now going to exploit this commercially, and you might say, yeah, you can give me 50 quid if you want to exploit it commercially. Or you can go off and license it commercially wider to a publisher or a particular body. So you are in control.
But wouldn't I... You just said the license was non-revocable. You said you can license it differently to somebody else. You can have a non-commercial license for educational institutions and a commercial one for a publisher of the same content.
The one thing I'll make straight about Creative Commons licenses, they're not educational licenses. They are licenses. So the educational sectors can use them because they're suitable for them. But anybody can use Creative Commons non-commercial license in a non-commercial way. But if you're the rights owner, you have the ability to keep licensing it non-commercially. The license is non-exclusive. You can license it any way you like because you're the rights owner. Does that make sense to people?
But that would be under a different license, not Creative Commons.
That's right.
Right.
Well, it could be another Creative Commons license if it fulfills it. Yeah.
That makes no sense to me.
Yeah. If you've issued your work under a Creative Commons non-commercial license, right, you can similarly issue your work under a Creative Commons non-derivative, a Creative Commons commercial, whatever.
Yeah, but they cancel each other out then.
Well, who cancels what out? Because that gives people...
Cancel out non-commercial.
If it's the same work.
If it's the same work, it can cancel each other out.
Yeah, but if you're the rights owner, you are in control.
Of cancelling out my own work?
No, of being in control of the work. That control stays with you all the time.
You wouldn't have more than one license at the same simultaneously, though, would you?
A rights owner can.
Right.
Yeah, a rights owner can. A rights owner can issue their work. The rights are non-exclusive, which means they're non-exclusive to you, leaving the rights owner in the exclusive position to license their work in any way they choose.
So I could negotiate with Lawrence to have a commercial license.
Yes.
But I'd negotiate with you to have a non-commercial license for my work of art.
Well, if I'm a different rights owner than you.
But if you license to me commercially, then it's valid everywhere, isn't it? You can't just do it with me.
No.
That's confusing.
No. Oh, make it available to the public. Yeah.
I presume once it's issued, it's issued.
Yes, of course it is. But what I'm saying is the rights owner is still in control. If you make this Creative Commons license available non-commercially, that's fine, right? But you can then do what you like. You can make another work or the same work available on commercial terms. That's fine.
I think
sectors do sit nicely. I mean, for example, it's slightly different, but anybody knows that copies of programmes put onto YouTube illegally are great creators of business for the rights owners. Now, the rights owners could choose themselves to make that content freely available, and some do. The OU puts a percentage of its course materials in Open Learn. They're freely available to the user. But it doesn't mean to say we don't make that same material as part of our courses. We charge students to study with us. I think what Bernie's trying to say is the control lays with the
rights owner at all time. If you make a work available under a commercial, Creative Commons commercial license, the fundamental basis of Creative Commons is you're getting no payment, right? So if you license your work on a commercial license, you're not going to get any money for that. But as a rights owner, you can do that because you're in control. But if you want money and you've already issued a non-commercial license and they come back to you, you do not have to issue them with a Creative Commons commercial license. You can give them permission on commercial terms and ask for money. You can create your own license.
So you're not limited by what you've done. You put it on Creative Commons. It doesn't limit.
No,
what you do with that.
no, not at all.
Exactly right.
It doesn't limit at all. That's the beauty of it. Yeah.
If I want to make any money, don't do it with commercial content.
Yes, because you do not get payment for once you put it on there under commercial Creative Commons license.
Come and see me.
Yeah, because she's good. Okay. Okay, thank you very much. We could go on and on. At least I could. Yeah. Thank you.